We learned quite a lot in Thursday's hearing in the Kohberger case on the state's motion to close the upcoming hearing on Ann Taylor's motion to compel certain discovery. But the big takeaway for me were the two magic words that Bill Thompson uttered: Touhy process. We're going to talk about what that means and why this is a big deal. So I went to Moscow for this hearing. This is one that I thought it was important to be personally present because it implicates the public's First Amendment right to witness criminal proceedings that are happening in court. I wrote an article about this on my Substack, which I'll go ahead and link in the description below. So I don't want to reiterate all of the First Amendment implications other than to just note that they exist. But the reason why then that I wanted to be personally present is because quite often, because of these rules, when courts are going to close a public proceeding like this, they often invite public participation, public comment on our interest in being able to attend and witness what is happening in the courtroom. So I wanted to be there in case there was an opportunity for public comment. Well, of course, if you watched the hearing on the live stream, you saw that no, the First Amendment wasn't mentioned at all throughout this entire hearing. I'm not going to fault Ann Taylor for that. She's focusing very appropriately on the Sixth Amendment right to a public trial that Brian Kohberger, her client, holds. That's her job, to advocate for her client and his interests, not to advocate for the public at large. But these are very similar and to some extent overlapping rights. They arise out of a lot of the same U.S. Supreme Court authority. But nevertheless, this has kind of been a pattern throughout the case that the public's First Amendment right is not really put front and center in the considerations of the parties. But nevertheless, we did have the opportunity to learn quite a bit about what is going on with this motion and with the status of the case. So there were several things that happened that I wanted to just go ahead and mention because they caught my attention. So first off, while I am in no way trying to be part of this story or part of this case, I've been there several times now. I think people are starting to get to know who I am. And I did have a brief moment with Bill Thompson before the hearing started, some eye contact, some fairly prolonged eye contact. And all I can really say is that it was not particularly friendly eye contact. But I bet you can guess who broke it first, huh? So, I don't know what all I'm going to take away from that other than clearly I'm not particularly sympathetic to the position that Mr. Thompson is advocating here. And, I am a defense attorney. My natural alliances are certainly going to be with the defense. I don't make any secret about that. But nevertheless, I have had some sympathy for Mr. Thompson throughout this process. And I continue to, particularly in light of what we have learned about kind of what is going on with these discovery issues from this particular hearing. Because I do think a lot of that we're now learning is beyond Mr. Thompson's control. This is not necessarily him that is trying to play fast and loose with discovery. This appears to be the FBI that is now throwing Bill Thompson and the town of Moscow under the bus. So I do have some sympathy for him for that. However, he's continuing to carry their water and to assert their claimed exemptions for why they don't need to participate in this process. So, for that reason, I'm going to continue to disagree, and that simply is what it is. But so that's just a little bit of the side drama, I suppose, that comes when you attend these hearings in person. It was very sparsely attended, not very many people there at all. I think that because the court is live streaming these now, there's just simply less interest, less motivation for people to be there, to be personally present. And I do wonder, like I mentioned, there's pretty significant First Amendment implications with closing a courtroom. And we've seen already in this case quite a bit of First Amendment litigation dealing with the gag order. And so I was kind of wondering, I asked the, the nice lady who handles the kind of press management, if she thought maybe Wendy Olson was going to be getting involved with this again. And she said she didn't know. But I do wonder if the fact that the press has kind of lost its exclusive on being able to, put this on camera and report it and so forth, that perhaps, maybe the First Amendment rights aren't so important for them to run out and vindicate anymore. I don't know. It's going to be interesting to see. So let's get into the meat of what we learned at this hearing about what this discovery dispute is about. What is the defense alleging the state is withholding? So the first thing are the videos that the state referenced in the probable cause affidavit that it collected of this white car, various pieces of information that they obtained from presumably all throughout the area looking for white cars that they could then match or try to match to this suspect vehicle 1 that they identified as potentially being associated with the murder. So according to Ann Taylor, what has happened is that the state is basically producing the ones that they want to use, the ones that they have cherry-picked, that they say, support the route that they're arguing that the white car took, but they are not producing all of them. And so that's significant for the defense because, of course, if there's a white car in the area where Brian Kohberger says that he was going, for example, making that right-hand turn on SR 270 to go towards Wawawe Park instead of the left-hand turn onto 270 to go over into Moscow, well, that would be significant, potentially exculpatory evidence that would tend to corroborate his alibi. So, of course, that's what the defense wants. They want everything that the state looked at, because with this type of evidence, a lot of times, what they're not choosing to use is just significant as what they are choosing to use, because they need to be able to justify their reasons for saying, well, this one is pertinent and relevant, and this one is not. So very understandable from my perspective that the defense would be wanting that information. Portions of the video of the King Road car, the white car that was circling the block and, making the 3-point turn and so forth. According to Ann Taylor, they have received portions of the video and long sections of the audio that have been withheld. This is a bit peculiar. Why would there not be audio on some of it, but there's audio on the main parts that the state is presenting? Really don't know. Is something being cut out and removed? Is it maybe a situation where there's like a motion detection that turns on the camera, turns on the audio? I don't know. But the state needs to be able to explain that and explain why they're only providing partial pieces. Once again, the stuff that is not there is often as important for the defense as what the state thinks is relevant and pertinent. But then the big stuff, okay, the big stuff, the cast report. They still don't have the cast report. This is shocking to me. I was really not expecting to hear this. Why? Because the cast report was the subject of the second motion to compel almost a year ago. It was, it's been on the table for a significant length of time. And so there was an order that Judge signed, compelling disclosure on this back in June of 2003, that these items are going to have to be going to have to be disclosed by July 14th of 2023. So we're like 10 months late here on getting this stuff. I did not expect this. So apparently they have received a draft and all of the supporting information. We also learned from this hearing, the state does not want to turn it over. So the cell phone information, the tower information, the drive test information, all of this stuff is being held close to the vest. It's not real clear who has what. We know from the probable cause affidavit that the state, it was the Moscow police, the local law enforcement that subpoenaed the cell tower information, the ping information, and then once they identified Brian Kohberger's phone number, obtained those records as well, those cell records specifically related to his phone number. So you would expect, okay, even if you give that to the FBI to do some analysis, that's in law enforcement possession, local law enforcement possession. You have that, you'd be able to turn it over. Why haven't you done that? Great question. This other stuff, though, the drive test and possibly also the tower info, it's not mentioned in the PC affidavit, so it is possible that this is something the feds went out and got on their own. And now they don't want to hand it over. And so we heard this magic word from Bill Thompson. We are using the Touhy process. Oh boy, this is pretty revelatory to me, because what that signifies is that the feds are not cooperating with the state when it comes to producing the basis for their conclusions, when it comes to backing up this expert that, based on the PC affidavit, is going to play a pretty important role in this case. This is the person who purports to be able to identify which towers the phone was using, to be able to show general location, movement of the phone, and then to corroborate that, to tie that to the video images that the state collected showing the movements of this white car. And that's such a critical part of the state's case here, because the white car and Brian Kohberger have to be connected for this theory of how these murders were conducted to correspond. If it's not his white car, then the existence of the trace DNA on the knife sheath becomes a lot more of an open question. How and why did that get there? If the car is not associated with his phone, then what happened to his phone? Where is he? Do you have some proof that his phone was somewhere other than he was, that it was taking a trip that he didn't take? So being able to link those two things together was a very important part of the probable cause that led to this arrest in the first place. If that connection gets severed, that's a pretty damaging blow to the state's case. So they relied on this FBI officer to be able to make that case. And now, apparently, the FBI officer doesn't want to disclose how he came to those conclusions. So they're invoking the Touhy process. Let's talk about what that means. So what is the Touhy process? Touhy is a U.S. Supreme Court case that said basically that subordinate federal employees can't be compelled in a state court to turn over documents that are held by the agency they work for. That's been extended to testifying as well. They can't be compelled to testify in a state court unless basically it complies with the provisions, the regulations that the federal department has adopted for that type of thing to take place. So as a practical matter, what this means is that every federal agency has what are called Touhy regulations, and they basically are setting out what's the process for if somebody in the federal agency gets a subpoena for documents or gets a subpoena to testify. So first off, why is this an issue at all? Well, because the federal government has sovereign immunity. You don't get to sue the federal government in state court or compel the federal government to do anything in a state court matter unless they consent to that. So the scope of that consent is basically, for practical purposes, what is set out in these Touhy regulations. So that means if you just subpoena a federal officer, subpoena them to show up for trial and testify, they don't show up, you don't have any enforcement mechanism as a practical matter. You can't sue them in state court because they will remove it to federal court, invoke sovereign immunity, and they will win. The case will be thrown out. So that's the exclusive mechanism then to compel a federal official to, basically turn something over from their files. You have to follow their regulations under this Touhy process. So the Department of Justice has adopted Touhy regulations for stuff that's held by the FBI. And there's a fair amount to it. It's not that complicated. You have to submit an affidavit explaining why you need it. You have to, describe with some specificity what you're looking for, show how it's relevant to the case, and so forth. But there are some significant parts of Touhy that are what tell me that this is strange. This is a strange posture, in my opinion, for us to be dealing with here. And so the first thing is that there is a catch-all provision in the federal Touhy regulations that basically says none of it prevents the FBI or Department of Justice, any agency, from being able to disclose information to local law enforcement, prosecutor agencies. Nothing in this subpart is intended to impede the appropriate disclosure in the absence of a demand. So, voluntary. Touhy regulations are limited to formal demands for things, subpoenas, court orders, stuff like that. They aren't even addressing informal cooperation, which happens between local law enforcement and federal agencies all the time. I mean, I can just think of examples where they have all kinds of regional task forces for various types of undertakings. There's one around here that's, I forget what it's called. It's like a fugitive apprehension task force or something like that. And literally it's just a bunch of cops whose job is to go out and arrest people who haven't reported to their probation officer. So, pretty petty low level stuff, but it's a task force. So there's representatives from all kinds of different law enforcement agencies in there, including federal officers. And so, when that person gets arrested and then, goes to court and challenges something, do you typically have to fight the FBI to get them to come in and testify about that? No, you don't, because they do so much of this stuff voluntarily through just cooperation without formal demands. And so what these regulations are really targeted towards is not having to comply with defense requests. It's me that they're not going to cooperate with. I'm the one that's going to have to try to compel them to give me information because they're not on my side. They're on the side of my adversary. So Touhy regulations are far more often things that the defense has to worry about and has to follow through on, not something that the state has to do, because the state can typically get this type of information without having to issue a formal demand. So then what happens when the department gets a Touhy request? Well, there's a specific regulation that says what they're required to consider and kind of the analysis that they're supposed to go through. So there are circumstances where they will never disclose the information that they have, but those circumstances are extremely limited. And it's basically if the material that you're asking for, it would be illegal for them to produce it. It violates a statute or a law, a regulation. It's statutorily confidential, like tax returns, or, it's something that, it's illegal to possess. The other situation is classified material, national security interests, trump everything. So those are the only circumstances where the department flat out will not, cannot provide the information that you might be seeking. But for all other circumstances, it's basically discretionary. They are going to consider, would this reveal confidential information like a source, a confidential source? Is this going to implicate some type of investigative privilege? Like, is there an ongoing investigation that could be jeopardized by this? Is this going to reveal methods that could impair the effectiveness of future law enforcement activities? And then the last thing they consider is trade secrets. Could this reveal trade secrets? This mainly comes up in a situation where, like, say the feds are investigating Kentucky Fried Chicken, and in the course of that, they learn the secret recipe, right? It's a trade secret. They're not going to disclose that, because somebody subpoenaed the Department of Justice, at least not by default. It's going to weigh against them needing to disclose that. But that said, even if those factors are present, the department still can disclose, and there's consideration to certain factors that they're supposed to give, including how serious is the crime involved? Okay. How important is this legal issue? How relevant is it to, basically the matter and being able to pursue the case that's at issue. So I'm just going to kind of put it out there that I'm not sure there is a more serious crime out there right now than the stabbing murder of 4 college students in their beds while they slept. This was a huge deal, this case. And so normally you would expect, there's going to be full cooperation from the FBI because the significance of this prosecution is so high. This is such an important case that if they, have the right guy and are really serious about having it solved and getting it addressed, well, then you want to convict him. You want to make sure you are going through the court process and offering, what support you have to be able to facilitate that. So the fact that, that seems to not have happened so far, it's just rather shocking to me. There has to be a reason for their reticence in turning over this basic information. So I did think it was significant that at this hearing, when the prosecutor, Ms. Jennings, was presenting her case for closing the hearing, she invoked some of these very specific exemptions that the Touhy process will consider. The investigative privilege, very specifically going through the items that were requested. She called out specifically, here's why we don't want to disclose this one. Here's why we don't want to disclose this one. Some of them implicate privacy interests and other issues. But a substantial number of these she relied on. These relate to an ongoing investigation, would jeopardize an investigation, and or would reveal investigative techniques and processes. So this kind of sounds like then behind the scenes, the feds have already communicated to the state what their position is on these particular disclosures. They've already raised these types of issues, and now the state is conveying them on behalf of the FBI in an attempt to resist the disclosure. So this is what I meant when I said at the beginning that, I might have a little bit more sympathy for the state if they weren't carrying water for the FBI in this situation. Because, I really do think it's the FBI that is the primary problem here. They're kind of hanging the state out to dry. But, if the state is willing to go along with that and sort of take the fall, then that's really going to be on them. But the problem is going to be basically whether these are going to have to be disclosed in order for the state to be able to present this cast evidence. And so let's go ahead and take a look at the discovery rules that apply, because I believe that, this is stuff that they are going to have to turn over, or they're going to be at risk of not being able to use this information. So the first Idaho discovery rule that is going to potentially apply here, the very first one, Rule 16A, applying to Mandatory disclosure of exculpatory information. This is classic Brady stuff. If it's potentially exculpatory to the defendant, you need to hand it over. And it's very notable under both the case law and under this rule. This is not limited, like many discovery requirements are, to items that are just in the prosecutor's possession and control. It extends to what's in the possession of anyone who has participated in the investigation or evaluation of the case, who either regularly report or have reported in that case to the office of the prosecuting attorney. So basically, if the FBI has reported to Bill Thompson throughout the course of this investigation about the cast stuff, then they're covered by this and they have to turn it over. And so what's implicated by that? Well, this is where the cherry picking of the video that Ann Taylor referenced is likely to be pretty significant. Because, like I said, if there's a video of the white car taking the right turn on SR 270, going the direction Brian Kohberger said he was going at the time he said he was going, and police chose not to rely on that, they have to turn that over still. That's potentially exculpatory because that supports his theory of innocence. It undercuts the state's version that, it was his white car that went on this route over to King Road and committed the murders. So very likely to apply in that particular situation. With respect to cell tower and other type of information, again, if it undercuts the state's theory, maybe it shows the range of the cell towers isn't consistent with where they're claiming to put him. Maybe the information that they got from his cell phone, might be a little more specific, might tend to put him elsewhere. That type of thing, you have to turn that over. That is squarely within Brady and within Rule 16A. But there's several other provisions in 16B too as well that particularly apply. So subsection 4, documents and tangible objects. Basically, if you got a document and it's material to the defense being able to prepare their case, then you have to turn it over, whether you intend to use it as evidence at trial or not. And so this is going to, again, apply to the video that they sorted through, the cell information that they got, all of this stuff. If the defense needs to be able to challenge, to evaluate the basis for the state's conclusions that this white car and this telephone belonging to Mr. Kohberger went to King Road and committed these murders. Section B5, reports of examinations and tests. If you're doing, scientific types of examinations like, a cell phone extraction, an analysis of cell records and things like that, then those reports have to be provided to the defense. Scientific tests or experiments, physical or mental examinations, if they're in the possession, custody, or control of the prosecuting attorney, or the existence of which is known or is available to the prosecuting attorney by the exercise of due diligence. So again, this one is broader than just the prosecuting attorney already has it. They have to go and get it. They have to make a reasonable effort to go and get it if they know that it's out there. So if there's a cast report out there that is not simply a draft, that is a full report, that is certainly going to be subject to this requirement. And then the last one is the expert witnesses. There's specific requirements for disclosure of expert witnesses, which, we know from the PCA, again, this FBI cast person is. This is not something that an average lay person can look at the data that you get from a cell company and interpret that into, some kind of meaningful location, like plotted on a map thing that will make sense to us lay people. You need an expert for that. So the prosecutor is required to provide a written summary or report of any testimony, and it must describe the opinions, the facts and data for those opinions, and the witness's qualifications. So this in and of itself does not require the data itself to be produced, but it does require the data they relied on to be disclosed. So then that's going to go back to the subsection before with the documents, the tangible things, the data that they relied on that's material to the preparation of the defense. There's interaction between those because the report is going to tell you, here's what I relied on. And then the documents and tangible objects are going to tell you, here's what I had. So that's where you get that extra piece of information about what aren't they using that is, often going to be material to the preparation of the defense. So what's the takeaway from all this? Well, it looks pretty clear to me that a lot of this stuff is going to fall pretty squarely within the discovery rules. The state is going to have to turn it over. They've already, the cast report, like we mentioned, they've already been ordered to turn that over and it hasn't happened. And so what happens if they don't comply with it? Well, the state will get sanctioned, and the most common sanction for this type of discovery violation is exclusion. The state is not going to be able to not produce what it has, deprive the defense of the opportunity to be able to fairly counter it, and then take advantage of that by still using that information at trial. That's just not a fair process, not how it works. So the risk here is that this cast stuff, if the feds continue to resist and the state can't turn it over, well, it might be excluded. We heard that Bill Thompson has now apparently submitted subpoenas to the court for him to sign for some of these FBI materials. They kind of spoke nebulously about, these are difficult processes that we have to go through. Maybe it should have happened 6 months ago. Yeah, at least 6 months ago, maybe this should have happened. But it does signify that apparently the state, according to Judge Judge, has been trying to get this information. And so it is the feds that are resisting here. I think that raises some real substantial questions. Why? Why are the feds jumping ship here? Why are the feds throwing the town of Moscow and the prosecuting attorney's office under the bus by willingly providing all of this information for them to rely on to be able to make an arrest at a critical point in this case? And now that it's time to actually, put up or shut up time, they're nowhere to be seen. This is really troubling. There's a lot of possible explanations for it, of course, but it's just really hard to come up with any that are not a big problem. This is such a serious case. They have cooperated fully so far. If there is nothing to hide, then why are we not fully participating with this process? Why are we not backing up our work? Why are we not making sure that our actions are not jeopardizing the ability of the state to go forward and make its case? Now, it's theoretically possible, say that the FBI doesn't turn this stuff over, that the state could go and recreate it. They could just go get a new expert, provide them all of the same information, and have them basically redo the type of analysis that the cast officer did. And so then they can just cut the FBI out of that part of the case. But, why would they need to do that? You're handing the defense just a weapon here that they can use by pointing out the FBI did all of this initial investigation and they're not coming in here to back up their work. There's going to be a concern that the reason why that's not happening is because the FBI's work can't be replicated. That whatever they did, whatever process they followed or conclusions that they reached are not going to be able to be substantiated by another expert. So perhaps that is part of the underlying concern here as well. I think this is telling in so many ways because as we've seen, as this case has progressed, we've gotten more and more willingness on the part of the defense to advocate for Brian. Okay, we've moved ahead, moved from he says he's going to be exonerated to our team firmly believes he's innocent to now with this hearing, Ann Taylor saying very specifically Brian Kohberger is innocent. Don't know what they're basing that on. I know a lot of people discount that or don't give that a lot of credit. I am not in that camp, okay? I'll just say right out that advocating that your client is innocent, taking this position in open court, it is quite remarkable to me. And it's for a couple of reasons. I mean, first off, your credibility with the court depends on the court seeing you as advocating reasonable positions. So if you're just out there willy-nilly saying all your clients are innocent, you know, when your clients are like on video committing the crime, then you're not going to have that credibility, and that's going to be a big problem for you in court. But the other reason is Ann Taylor is a public defender, okay? And the public defender, you see the entire mill of the criminal justice system. You see everybody that goes in and goes through. And you have been burned so many times by clients that swear up and down they're clean and pure as driven snow, perfectly innocent, don't have anything to do with it. And then, you know, the police report and the discovery show up and there they are on video doing the crime right in front of your eyes. So you're very accustomed to people saying they're innocent when in fact they're not. So you learn to be very careful about the strength of the positions that you assert for people, simply because you just don't know what might be out there. You are kind of limited in how much trust you can give people just on the basis of their word alone. Certainly not until there's a lot more information that's available. So they're at a point in the case now where, yeah, they have a lot of the information. They've had Brian's story. They've had their own investigation. And based on that, they're making these representations. That's very significant to me. But the other comment that was made in the hearing that I thought was pretty significant was Judge saying, when this case gets to trial, if it gets to trial. Oh, man. He's seen everything that's going on here that we're not now going to be privy to. And, you know, calling into question whether we're going to make it to trial. I suppose it's possible he's referring to a plea bargain, right? Maybe there will be a plea bargain and we won't get to trial. Certainly can't rule that out. But we haven't had a plea bargain so far. And, you know, Brian has been sitting in jail for 1.5 years now. So I just got to call into question what that's really, whether that's really what would motivate that type of statement by Judge. It seems far more likely that he knows a lot more about the case, is privy to what is going on behind the scenes, and maybe potentially has some concerns about the viability of this case even going forward. So this is telling. I mean, the case, it didn't start off on the strongest footing. It was very much anticipated that the bulk of the case was going to be made after the arrest, with the phone, with the computers, with the access to the car, all of that information. It was supposed to be a gold mine. It hasn't panned out. And now even the stuff that they did have, the state's witnesses don't want to come to court and back it up. This case is crumbling. There just really isn't another way to put that. And that's how I have to interpret that statement that Judge made about if this case goes to trial. So for now, the upcoming hearings on the 14th and the 16th, they're going to be closed. We are not going to see them. Judge has issued a written order on this decision to close the hearing on the 14th. I'm going to probably write up something about that on my Substack. So if you're interested, go ahead and head that way and keep your eyes open. I do think that this is not a good decision, not a correct decision on his part for a number of reasons. So we'll go ahead and break that down a little bit. But then we also learned there's probably going to be some kind of ongoing status type of hearing date in the court. So they talked about setting these things on Thursdays, just so that there's a predictability to when things can be calendared when motions come up. Got a pretty preview of coming attractions from Ann Taylor. Motions to suppress are coming, not a motion, not maybe a motion, motions in the plural. So that's going to be interesting. It's going to allow us to see some of the allegations about the conduct, the underlying conduct that led to the discovery of some of this information. The defense is clearly going to take issue with it, argue that it's a violation of constitutional rights. We know what some of that is, more than likely through the IGG hearing, for example, the suggestion that the FBI routinely will access the personal profiles of individuals who have opted out of law enforcement searches. This is a novel issue legally. It's very interesting to me. So I'm going to be, paying very close attention to that one if that does indeed come up. But there's not a lot of law on it, so that's going to be something that's interesting to see how that unfolds. And then, in the meantime, just given how things have been going, kind of expect might be more discovery stuff as things get closer and closer to the deadline. So we'll see how all that unfolds. In the meantime, like I said, do go check out my Substack. I'm going to do a lot of stuff in writing there just because I can get that out a lot faster than I can produce these videos. So I am going to have a lot more of my thoughts kind of out in that format. And in the meantime, I guess until there's another hearing to look at or talk to, I probably won't be covering this case on here. So once we have something new that's coming up, we'll look at following that and maybe live streaming it or something like that. So do stay tuned. This case continues to be fascinating. It continues to be surprising and have all kinds of unexpected twists and turns. So stick with me and we'll continue to see where this takes us.